Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines, where my guest is my law partner, Sean Fagan. We're going to talk to you about the litigation process. You can settle a claim before you have to file a lawsuit, but if you don't, you then file the lawsuit and the litigation process is collecting information. Hopefully you settle it before you have to go to trial. If that doesn't work, you go to trial. We tell you about that process. So join us on the next Legal Lines with attorney Sean Fagan.
It's time now for Legal Lines Tips with your host, Locke Meredith.
Hello, I'm Locke Meredith with a Legal Lines tip for you. If you have to hire a lawyer, and I hope you don't, but if you do, hire a lawyer that you like, that you trust, and who specializes in your area of need. In these days, with all the laws we have, lawyers for the most part now specialize. They specialize in contracts, defense, business, personal injury, all kinds of areas of the law. So when you interview with a lawyer, ask him, does he specialize in the area of your need? Has he tried the cases? Has he been successful? And of course, how does he charge you? Is his fee hourly? Is it a percentage of the case if he recovers? What exactly does he charge? So my Legal Lines tip from me, Locke Meredith, to you is, if you have to hire a lawyer, hire one you like, you trust, and who specializes in your area of need.
This has been Legal Lines Tips with your host, Locke Meredith.
Welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have back on the show my law partner, Sean Fagan. Sean, it's great to have you back. And what we want to do today, folks, is kind of try, and it's going to be difficult, to take you and educate you through the process of if you're injured in an automobile wreck, let's say, all the way through the legal process if you decide to present a claim. So let's begin with that. First of all, we got three kind of periods of time that we're dealing with here. Sean, explain that to folks.
Well, the first part of obviously is the accident itself. And you're trying to figure out, what do I do? Do I need a lawyer? Do I not need a lawyer? I tell folks a lot of times when they come in, there are situations you don't need a lawyer. If you have a sprained thumb, you don't need to go see a lawyer for that.
Exactly.
But the more complicated the injury, the more significant the injury, the more lasting effects you have, you're probably being foolish you don't at least consult a lawyer to find out what your options are.
And so kind of the first period of time is you're in the wreck, you've decided you need to present a claim that we're going to discuss, but you don't have to file a lawsuit. It's settled before filing a lawsuit. The next kind of period of time that we're going to discuss is you've done that, it didn't work, it didn't settle, so now you got to file a lawsuit and you begin the formal litigation process. And then the third segment of the show is going to be on the last part where it still doesn't settle, even though you've gone through the formal litigation, but you haven't gone to trial yet, but now you have to go to trial. So let's just make an example. Let's say somebody is involved in an auto accident or hit by a big old truck or something, and they're injured, and they know they're injured, and it seems serious to them. What should they do?
Well, the first thing you do is you document everything.
Right.
You've got a limited amount of time out there at the scene. The police officers usually come to investigate, but they may not get everything. So nowadays, people have their phones. Take pictures.
And pictures paint 1,000 words.
And so get the photographs, get names of witnesses. Sometimes people come and they leave the scene, and the police officer may not get their names, may not get their addresses, but be sure you get it. Make sure you get the other side's insurance information.
Right.
But first and foremost, some people may walk up and say, look, here's my insurance information, let me go, and you can call me later. Never a wise idea, especially in an accident where you feel like you may have been injured.
I'll actually even add this because of the cell phone technology. Record your conversations with both any witnesses or the persons who's at fault for the collision, and frankly, even with the police officer, in case they misunderstood what you said and their written report isn't exactly what you said, because that's extraordinarily important.
Yeah, excellent point. And so once that's done, hopefully the documentation's been gotten, now the question becomes, do you need a lawyer? And if it's a serious accident or one where you're not sure of the extent of your injury, absolutely, go in and consult. It's not going to cost you anything.
Agreed. And frankly, we tell folks when they come to see us, your job, if you have a job, is to get well, get treated. Go see the doctors. If you're hurting, make sure you tell them everything, both the past of your health, regarding your health, what happened in this accident, what hurts. A lot of times folks try to suck it up, particularly men, and they're going to be macho man, and they're not going to say anything when they're hurting pretty bad, but that's not what they should do, number one, because the doctor needs to know what's wrong so that they can diagnose the injury and also treat it effectively.
Yeah, and the importance is documenting everything. There may be something that's bothering you, maybe a 3 out of 10 right now, but this other area of your body is a 7 out of 10. You mentioned a 3 out of 10 because you don't know if the 7 out of 10 gets better, the 3 out of 10 becomes worse. If you've never mentioned it before, it may not be on the radar screen, and of course the insurance company is going to point that out, that you didn't mention it to the physician, even though you say that's what happened from the beginning.
And it's important for us to advise folks that if they receive a phone call, even from their own insurance company, much less, and obviously the other side's insurance company, they should not give a recorded statement until they go see a lawyer. Because I say this all the time, knowledge is power. And you're going to be able to talk to a lawyer for free. Go in there and figure out what your rights are, what the responsibilities are, what the issues are, so that you can make an educated decision.
Well, the truth of the matter is, you have no experience with an insurance company, the regular person. The insurance company takes recorded statements every day.
That's right.
And so
they're not calling you to make sure that they're going to pay you every dollar they have to pay. They're calling you to try and, for the most part, figure out why they don't have to pay.
That's right. So if you, it's kind of like walking into a gun battle with a knife, as they say. You know, you're not prepared, and so you're better off to be prepared. And you know, insurance companies, they're generally honest people that you're dealing with, but then there's some that aren't going to really treat you fair, and you better be prepared for that situation, because if you're caught in it, you're caught in it.
Right. So they go see a lawyer. How do they decide what kind of lawyer to hire?
Well, if it's a civil case, obviously you're coming to a lawyer that does personal injury type litigation. You want to know, are they experienced? Check them out. You're hiring them. They're going to be the ones that are doing the work for you. But I guess really the bottom line at the end of the day is, if they've got experience and you know they've got experience, you've got to trust them.
Well, and go to the website, because you're going to learn from their websites whether or not they know what they're doing, because it's going to reflect their successes. But also, and you said it, there has to be a relationship of trust between the client and the attorney, because if there is not that and the client doesn't feel comfortable with the attorney, it's just not going to work.
That's right. I mean, at the end of the case, the attorney's going to make, or if there's money that's being offered by the insurance company, the attorney's going to make a recommendation to either accept it or to reject it. And at that point, you've got to trust the lawyer and know that he knows what he's doing and that he's worked your case up well. Because if he doesn't know your case, doesn't matter how good the lawyer is, he's not going to do right by you.
So let's assume in this particular example that it's an injury that wasn't horribly severe, that the client heals up within 3 to 4 to 6 months, whatever it is, and they're okay. They've been healed. They have no long-term problems. Then at that point, all the information is collected from the doctors. A settlement package is put together, and then what happens? Well,
the settlement package is sent over to the insurance company, and that's what we do. Is obviously we try to give a very concise explanation and summary of all the medicals. That way the insurance adjuster knows exactly what they're dealing with, date specific, what doctors have done what in terms of treatment, and now what the prognosis is. At that point, the insurance company can assign a value to it.
And of course we do too when we send out the settlement letter. We tell them what we say the value of the case is. We'll justify it with case law if necessary to show what the value is and why we're right. And then negotiations take place, and you go back and forth, and sooner or later there's a figure, hopefully, that the insurance company offers that is within the reasonable range, and we talk to the client.
That's right. What we're trying to do is not blow a client's money. And we're maximize what's going into their
pocket
to compensate them.
Walk away with.
And so you don't start off by filing a lawsuit generally. In most cases, you're trying to get the patient and the client to the point where they've reached maximum medical improvement. You try to resolve the case.
And so when the number is proposed by the insurance company that the attorney believes is reasonable, their job is to tell the client it's reasonable and here's why. But the bottom line is this: the client is the one who decides. We make a recommendation, but they decide whether that is a sum they're willing to accept. And if it's not, the next step is trial. So we're going to talk about that on the next segment. This is Locke Meredith Legal Liens. Attorney Sean Fagan will be right back.
It's time now for Legal Liens Tips with your host, Locke Meredith.
Hello, I'm Locke Meredith, and I have a Legal Liens tip for you. Remember, knowledge is power. And I want you to know if you're injured, Louisiana law grants you a variety of claims to make sure you're fully compensated. generally chopped up into several categories, the first being general damages. That's going to compensate you for your mental and physical pain and suffering, your scarring, disability, functional limitations, your loss of enjoyment of life. Also, it will compensate your family, frankly, for your loss of affection. It's called loss of consortium claim. Next category is specific damages. Those would be, say, for example, past and future lost wages, past and future medical expenses. You also have a claim sometimes for what's called punishment damages or punitive damages, typically only available when you're injured by a drunk party. Finally, you're entitled to legal interest from the date you file your lawsuit until you're paid and court costs. So my Legal Lines tip to you from me, Locke Meredith, make sure you know what your claims are.
This has been Legal Lines Tips with your host, Locke Meredith.
Welcome back to Legal Lines. Again, I'm very pleased to have on the show Sean Fagan. He's my law partner, and we're talking about the process of a claim all the way through the end of a trial and try and summarize this for you in 3 different stages. Sean, the first stage was a settlement prior to having to file suit. The next period of time is, don't settle it during that time, so now you have to file suit and you begin the formal litigation process up to trial. Sometimes they settle prior to the trial, and the final segment is going to be the trial. Let's talk about that middle area where didn't settle, you've had to file a lawsuit. Tell folks what happens.
Well, at that point, usually what the discovery process starts. That's where they get to ask questions of us, we get to ask questions of them, depositions are taken, different things occurred all the way up until the date you're selecting a trial date. Most cases do settle. Why don't all cases settle? Well, because there's usually complicated issues that are there, questions that need to be answered, disagreements. Somebody may say, this is how it happened. The other person may say, this is how it happened.
So you have to go through the formal litigation process to hone it out. And really, the very beginning of it is we would file on behalf of our client a petition, a lawsuit. And that suit outlines the facts as we understand them, what the injuries are, what the damages are, which there's a litany of all kinds of categories of damages that a plaintiff, an injured victim, is entitled to. And then the next step is, and of course sues the parties any party who's potentially at fault, because in Louisiana we have a comparative fault and a whole fault regime where anyone who is maybe 1% at fault up to 99% at fault can be sued and should be sued.
That's
Explain
right.
that.
Which we bring everybody in that could be potentially liable for the accident. And then after the discovery is complete, you get a chance to figure out, are all these people, do they need to be in there? Some may not. Maybe we can dismiss some.
May learn some new people
That's right.
who are at fault.
That's right. Oftentimes we may find out that the vehicle not only has one insurance policy, but may have 2 or 3.
Exactly.
And so you don't find that out to the discovery process sometimes, and so you add additional insurance companies. That way, if you have a very serious injury, the person doesn't wind up undercompensated.
And when we file a lawsuit on behalf of our clients, the defendants, which usually obviously in this case if it's an automobile collision, would include the person who, let's say, rear-ended our client and their insurance company, and maybe they were in their course and scope of employment for an employer. They were on the job, and so you sue the employers and also their insurance company. And all those parties are served with the lawsuit. They get their attorneys, and then they'll file what's called an answer. Usually 99.9% of the time they deny everything, and they're going to say it's everybody else's fault but theirs. And even the plaintiff, they'll even say it's the plaintiff's fault.
And so the answer is filed, and then at that point it's joined. Both sides are now into the courthouse, and that's when the next phases start. Well, the things we talked about earlier, the discovery, interrogatories are sent back and forth.
Well, let's talk about that. When we say discovery, that's lingo or jargon, legal jargon. And discovery is nothing but an exchange of information, documents, evidence between the parties so that they know what the other person has or side has, and vice versa. Explain, first of all, the interrogatory. It's just a fancy name.
Fancy name for questions.
That's right.
Discovery, if you think about it, is exactly what it sounds like. They're trying to discover everything about your case. You're trying to discover everything you can about their case. So the first thing they do is send questions. And they'll send questions to our clients, say, tell us about yourself. Tell us about prior accidents. Tell us about prior injuries, prior health conditions. Things that they want to know about to figure out how much damage did our accident cause this person.
Our discovery is also to them, our questions to them is, what witnesses do you know about? What insurance coverages do you have? What insurance coverages might you have? Is there anyone else you think's at fault? Do you admit that you're at fault in this stuff? And so both parties are sending questions to try and bolster their position as to what the truth is.
And once we get that framework, that information that we have, then usually we move into depositions, which are where the opportunity that we have to ask the other driver or other witnesses, what did you see? What do you know? It's all under oath, and the other side has the same opportunity to ask our clients, as well as any doctors that may be treating clients, what's the person's condition.
And even prior to the depositions, in that kind of discovery process where there's an exchange of information, you can ask for the production of documents. You got any video of this stuff? You got any statements that your employer took of you or any witnesses? Are there photographs that y'all have? Send us a copy of the insurance policy so we can make sure there's coverage. Because a lot of times insurance companies will say, we don't provide coverage here. And so you're saying, send me all the documents that you have, all the photographs, all the video, anything that you have. The other kind of very interesting and frankly I think useful discovery is the request for admissions of fact. Explain that to folks.
Well, that's when you send a question to the other side that says, well, it's not even a question, it's a statement.
Admit or deny?
Admit or deny that this is the case. Admit that your client is completely at fault for this accident. Admit that the light was red. Admit, depending on what the facts are, you ask them to admit certain things, and if they admit them, then it makes it much simpler for us when we go forward in the litigation process because it streamlines the issue.
Exactly. So you were talking about depositions, and of course the purpose of the deposition, and you noted, it's under oath. It's like testifying in court. That document will be used once it goes to trial and testimony is being elicited from, say, the defendant or their experts. And if they say something on the stand that's different than what they said to us in their deposition when we asked them the same question, we're going to beat them over the head with that deposition and that statement. Explain.
Well, that's correct. And we're moving ahead now to the trial segment, but all attorneys know that when your client is put under oath or a witness is put under oath, that if they don't tell the truth and it comes out later, that statement under oath not only is going to be used against them, but could be used against them criminally.
That's right. And it's interesting because you can ask questions in a deposition you cannot ask at trial. For example, and we have to explain this to our clients, you can say, have you ever been convicted of a crime? And the client always goes, why is that relevant to this guy running into the back of me? Explain to folks why they can ask questions like that.
Well, again, it's to get more information about the person. A lot of times when we get to a trial phase, or even when you're trying to mediate a case or discuss or negotiate the case, it's about credibility. Can we believe what the other guy said? Maybe the other driver says this is the way it happened. The same thing about our driver. He says this is the way it happened. So you dive into their history a little bit, and let's say you've got somebody that has been convicted of a crime of forgery or something like that. That is an indication of, well, can you rely on their truthfulness?
And they have to tell the truth. And if they tell the truth, they can't ask that question at trial.
Correct.
The other thing that happens before trial is motions are filed, motions that hone the issues for the trial so that, for example, if the defendants admit they're liable, the only issue is what are the damages that are incurred by the victim in this case. So we'll move on to the next segment and discuss that along with the trial. This is Locke Meredith Legal Lines. My guest, Sean Fagan. We'll be right back.
It's time now for Legal Lines Tips with your host, Locke Meredith.
Hello, I'm Locke Meredith, and I have a Legal Lines tip for you. Remember, knowledge is power. And I want you to know if you're injured and you have lost wages because of that injury, Louisiana law gives you a claim for that loss. Typically, it's going to require medical evidence from a medical doctor stating because of your injuries, you can't work. It's a pretty simple claim. If you had a job before the injury, doc says you can't work from the date of the accident, and 3 months later he says you can work, you can figure out what you've lost in wages. Circumstances occur, however, when the injury results in permanent physical and functional limitations. Now you can't do the job according to the doctor that you could do before the accident. So the question becomes, is there any work you can do, and what is the difference in wages? But the court doesn't just look at what you earned in the past, it also looks at your earning capacity. That is your ability to earn wages in the future, promotions, additional education. So my Legal Lines tip from me, Locke Meredith, to you is make sure you know your rights when you're presenting that lost wage claim.
This has been Legal Lines Tips.
Welcome back to Legal Lines. I'm Locke Meredith. Again, have as my guest my law partner, Sean Fagan. Sean, let's dive right back into it. We're shifting to the trial period of time. It hadn't settled before, so now you got to try the case. But before the trial, there are motions that are filed potentially by both sides. Let's discuss those quickly.
Motions for summary judgment, motions to strike affirmative defenses, what is all that? It means we're trying to streamline issues. The other side may bring up defenses that they think are comparative fault being one that you mentioned earlier. There may be no evidence of comparative fault. It's a rear-end collision, our guy didn't do anything. File a motion to get that out of the way so that when we get to trial, the jury hears really the meat of the arguments.
And what we're telling the court is, look, there's the legal jargon, no material issue or question regarding the facts or the law as it relates to these facts. Therefore, Judge, this should not be an issue in the trial. And like you said, for example, liability. If there's no evidence that's been developed during the discovery part of this litigation that no one but that defendant that we've sued is liable, you present that information via affidavits and deposition testimony to the court, and the court says, yeah. So he strikes that as an issue that either he or a jury is going to have to work on.
That's right.
There's also, and there's multiple motions that hone the issues and hone the parties for trial, but there's a very important document called the pretrial order. Explain that to folks.
The pretrial order frames the issues. Once the petition lays out what our allegations are, the pretrial order lays out what we're going to present at trial, the arguments that are going to be made, the legal issues that are there, the facts are going to be presented. If it's not contained in the pretrial order, it's not coming in.
And it's very important, and because it's kind of like the Bible. It's the law of how this trial is going to move forward. And you are required to identify what your claims are, who your witnesses are, what the exhibits are. And if you try and call a witness, except on very limited circumstances, or present a document that hasn't been identified by you in that pretrial order before the trial, it's not going in.
That's correct. So if you don't do your job right,
that's right,
you can harm your client immensely during a trial.
And we've used that effectively before against the other side. So let's shift gears. So hadn't settled, now we're going to trial. Explain the first thing that happens in the trial preparation process. Folks are there in the courtroom, the judge is up there, explain what happens.
First thing you have to do is pick a jury if it's a jury trial. It can also be a bench trial. In Louisiana, if the claim is under $50,000, you can try it directly to the judge. You usually get a trial date much more quickly, but if it's over $50,000, a more complicated case, you try to a jury. So the first thing
you're not required to.
Yeah,
I mean, if it's below 50, the judge is going to decide it. If it's above 50, you can request a jury trial, and different parties at different times decide whether they want which one method they're going to try the case.
That's right, it's optional.
And so the jury has got to be picked, but it's picked from who? How does that take place?
Well, it's sent out by the clerk of court. They send out a notice to certain people in the parish. You can't have been convicted of a felony, but it's just you and I, people that are out there, and they come in and they go through a process of jury selection that lawyers call voir dire. And that's when they come up, they have a chance to ask them questions, find out a little bit about them. Do they have any hang-ups? Or is there a reason why they couldn't serve
biases,
as a good juror?
reasons why they wouldn't make a good juror. And really, there's 50, 60, sometimes 70 folks sitting in the courtroom. 12 of them are called up, they sit in the jury chairs, and the plaintiff lawyer asks them questions, and the defense lawyer asks them questions, and then there's these things called challenges. Explain the challenges quickly.
The challenges are there when you think the person may be biased or may not be able to serve as a good juror.
And there's two kinds of challenges.
Yeah. One is where you've really what you're trying to do is say the person, if one has a bias, you'd say.
So you don't like that juror, you want them out of there.
Yeah, it's one that the judge says, look, this person can't serve as a juror, they're out. The other one is like an elective one. You say, this particular juror I don't have a good feeling about, judge. There's nothing, they're not biased or anything like that, but I don't feel like they should be there. The judge allows you a limited number of those. The challenges for cause, which are bias, other things like that, there's no limit to those.
Right, but the ones where you can just say, I just don't like the way they looked at me, those are very limited.
Yes.
And so you have to be strategic about how you use them. All right, so now let's say the jury's picked. You also have a couple of alternates in case a juror gets sick or they do something wrong and they're booted from the jury. And what's the next thing that happens?
Well, the next thing is that the trial commences. You have your opening arguments, or actually it's opening statements.
Right.
You're basically telling the jury, this is what you're about to hear. and this is the evidence, these are the witnesses, and you lay out your case. And then after that, of course, comes the calling of the witnesses as we go forward.
And so both parties get a chance in the beginning to tell their story to the jury and say, look, this is our version of what we believe the truth is. These are the facts. This is what so-and-so is going to say. And this is basically why this happened and why the other side's liable and why they need to pay damages. The other side comes back and says, no, we didn't do anything wrong. It's all their fault or somebody else, and we shouldn't be here. Leave us alone. And that's the opening statement. So then the next stage is the commencement of the presentation of the evidence to the jury. Explain that.
Those are the witnesses. That you present your case not through the arguments that we make as
That's
lawyers,
right.
but through the people that come and testify in front of the jury.
In fact, there's an instruction by the judge to the jury. Hey, when the lawyer talks to you, that's not facts. That's not evidence. That's the lawyer just talking to you, and you don't have to believe a word he says.
That's right. And the juror's job is to ferret through what the lawyers are saying and going in directly what the witnesses have said and what the evidence shows, the exhibits.
And so the presentation of the information and evidence to the jury is obviously the victim who's been rear-ended, any witnesses that might agree with how he's saying it was the other party's fault, the people that we've sued. It would be the presentation of maybe the medical professionals who've provided treatment and diagnosed their injuries and said they're going to not ever go back to work again, at least not in that kind of job.
Could be accident reconstruction.
Right, could be experts.
How did the accident happen?
Or economic experts who say, hey, he's not going to go back to work. He was making this much money. He's going to lose money into the potentially hundreds of thousands or millions in the future. And then the other side gets to call up their side and do the same thing. But while you're presenting that evidence, they have a chance to come up and question each and every one of those witnesses and try and challenge them and show why they're wrong to the jury.
Mm-hmm. So then after we finish through that phase, then it's closing arguments. And that's when you're not presenting the statement of the blueprint. Now you're arguing what the facts are to the jury and telling them this is what you heard, this is what we believe it shows, and this is why we believe you should rule this way.
It's also important to we tell them always, and here's the law, here are the facts, here's the evidence, here's the law, here's how you apply that law to this evidence, and these are the damages. And we literally will tell them what we believe is a reasonable range of damages to award for a litany, all kinds of categories of damages. The other side gets to do the exact same thing. The judge retires the jury after giving them a jury charge of what the law is, and then hopefully they come back and render a verdict on behalf of our clients, but that doesn't always happen, and then there's an appeal process. Sean, been great to have you on. This is Locke Meredith, Legal Liens, Sean Fagan. Thank you for being with us.